Good morning, AAT member. My name is Faye Brewer and I'm the legal representative for the applicant, Rosen Smythe. I acknowledge that a legal representative for the respondent, Sport Integrity Australia, being an Australian government agency for the purposes of the Freedom of Information Act 1982, is also in attendance today. I understand that you have all relevant documentation before you, including my client's original letter requesting documents from the respondent, the response from the respondent, the application to the Australian Information Commissioner for external review, and also that response. Pursuant to Section 57A of the FOI Act, the applicant is seeking an external review of the Acting Australian Information Commissioner's decision to refuse access to documents under Section 55K of the FOI Act. The documents the applicant seeks are test results, including doping control forms. I will refer to these as the doping control forms from here on in. I will now provide you with a brief chronology. On the 3rd of February 2023, the applicant applied to SIA for access to documents relating to 3 players of the Shamrock Softball Club based in Halifax, Queensland, Australia. On the 1st of March 2023, SIA advised the applicant that it had identified several documents within the scope of the request. However, it refused the applicant access to all of the documents in full. In making its decision, SIA relied on Sections 45 and 47G of the FOI Act. The applicant subsequently narrowed the scope of the request to the doping control forms. On the 7th of March 2023, pursuant to Section 54L of the FOI Act, the applicant sought a review by the Information Commissioner of SIA's decision. On the 1st of April 2023, the Acting Information Commissioner changed the basis on which the respondent's decision was made. He decided that the doping control forms were conditionally exempt under Section 47E, subsection D of the FOI Act, and that giving the applicant access to these documents at this time would be contrary to the public interest under Section 11A, subsection 5 of the FOI Act. In order for my client's request to be conditionally exempt under Section 47E, subsection D of the FOI Act, it would need to be shown that disclosure of the doping control forms would, or could reasonably be expected to, have a substantial adverse effect on the proper and efficient conduct of the operations of SIA. Accordingly, AAT member, I submit that the Acting Commissioner has failed to establish that. First, I submit that the Acting Commissioner has been unable to demonstrate that the substantial adverse effect that disclosure could reasonably be expected to have on the proper and efficient conduct of SIA's operations. At paragraph 16 of its decision, the Acting Commissioner asserts that disclosure of the doping control forms could reasonably be expected to reduce the competitiveness of SIA to provide user-pays sample collection services for Australian sports. The Australian Commissioner appears to have relied on the respondent's reasoning at paragraph 12 of its decision that disclosure would lead to a maximum 10% loss in SIA's annual revenue. In doing so, I submit that the Acting Commissioner has incorrectly concluded that this amounts to a substantial adverse effect on the operations of SIA. I contend that a 10% or less annual loss in revenue is a trivial percentage which does not amount to the requisite standard of substantial loss required under Section 47E, subsection D of the FOI Act. In the case of Tillerman's Butcheries and Australasian Meat Employers Union and Oars, 1979, at page 11, Justice Dean is very clear that the word substantial requires loss or damage that is, in the circumstances, real or of substance, and not insubstantial or nominal. Such reasoning has also been reinforced at paragraph 5.20 of the FOI guidelines. Further, AAT member, I submit that the Acting Commissioner has failed to provide any evidence that disclosure could reasonably be expected to reduce the competitiveness of SIA and yield up to a 10% annual loss in revenue. In the case of Ori Actors Equity Association and Australian Broadcasting Tribunal No. 2 of 1985, at paragraph 12, the tribunal asserted that the phrase could reasonably be expected requires more than an allegation or speculative possibility that damage may occur if the document were to be released. It needs to be an expectation that is based on reason. This is reinforced at paragraph 6.101 of the FOI guidelines. However, I submit that at paragraph 16 of its decision, the Acting Commissioner has merely accepted and regurgitated the respondent's assertion that such an effect would occur following disclosure of the doping control forms. Paragraph 5.21 of the FOI guidelines state that the Acting Commissioner ought to have clearly described the expected effect of disclosure and its impact on the usual operations of SIA in its statement of reasons. I therefore submit that the Acting Commissioner's decision demonstrates that, similar to the case of E and National Offshore Petroleum Safety and Environmental Management Authority 2012, the respondent has failed to discharge their onus of proof contrary to Section 55D, subsection 1 of the FOI Act. Second AAT member, I submit that in accordance with paragraphs 6.123 of the FOI guidelines, the doping control forms cannot be found to be conditionally exempt under Section 47E, subsection D of the FOI Act. That is because their disclosure is highly likely to reveal that the respondent has acted unlawfully, inefficiently, or beyond an expected activity that the agencies were set up to undertake. Based on the information I have obtained from my client, I have strong reason to believe that the positive test results were a result of a conspiracy between a member of the softball community and an individual or group within the employment of the respondent, the aim of which was to strip the Shamrock Softball Club of its success, its status, and its financial resources for the benefit of other teams and players competing in the national softball competition. I therefore submit that disclosure of the doping control forms is crucial for revealing the unlawful activities of the respondent. AAT member, in the event that the doping control forms are found to be conditionally exempt from disclosure under Section 47E, subsection D of the FOI Act, I submit that on balance it is in the public interest under Section 11, subsection 5 of the FOI Act to disclose those documents. Pursuant to Section 11B, subsection 3 of the FOI Act, the relevant public interest factors weighing in favour of disclosure are: first, that the objectives contained in Section 3, subsection 1 of the FOI Act demonstrate that there is a bias in favour of disclosure. As put forward by Deputy President Forgy at paragraph 68 in the case of Bell and Secretary, Department of Health 2015, I submit that disclosure of the doping control forms will fulfill the public interest in ensuring that government agencies such as SIA are being properly conducted and are held accountable. In this way, disclosure will promote transparency through increased scrutiny of government activities in accordance with Section 3, subsection 2, subsection B of the FOI Act. Second, I submit that in the circumstances such as these, where the respondent is highly likely to have been involved in a conspiracy, then the disclosure of the doping control forms is required for the objectives of SIA contained in Section 3A of the Sports Integrity Act 2020 to be realised. That is, to prevent and address threats to sport integrity in Australia and minimise loss in public confidence with a view to achieving fair and honest sporting performances and outcomes. This is of particular importance when we consider that the Shamrocks board have accused the applicant of being solely at fault with regards to the positive testing of all three players. As a result, the applicant has suffered serious detrimental effects to her reputation and career. Para 6.6 of the FOI guidelines emphasise that a matter of particular interest or benefit to an individual or small group of people may also be a matter of general public interest. I submit that the applicant deserves to be given an opportunity to prove her innocence. In considering the relevant public interest factors weighing against disclosure, I disagree with the Acting Commissioner's view at paragraph 21 of the decision that disclosure has the potential to prejudice the effectiveness of SIA's testing or auditing procedures. I submit that any sensitive material ought to be redacted pursuant to Section 22 of the FOI Act, which would eliminate this issue. Further, Given that the acting commissioner himself admits in paragraph 15 of its decision that SIA's testing is random, it is difficult to see how the names of the players, the dates that the samples were collected, and the instances of the collection would in any way allow for the future testing predictions to be realized. I must emphasize that the embarrassment or loss of confidence in the Commonwealth Government that disclosure of the doping control forms may cause is not to be taken into account pursuant to Section 11B, subsection 4, subsection A of the FOI Act. To summarise, I submit that the public interest factors in favour of disclosure outweigh the public interest factors against disclosure. Disclosure of the doping control forms would not, on balance, be contrary to the public interest. AAT member, I submit that the doping control forms are not exempt from disclosure for the reasons I have stated, and I respectfully request that you make a decision granting access to the applicant. Thank you.